Hey guys, Rogue Nation here with you tonight, and got some footage we're going to show at the end of Chris's for public safety's arrest, and we've honed in on what we think the charges are that they're charging him with. I still haven't seen a probable cause affidavit, so I don't know the exact details on what they're charging him with, but we're going to go over the charges that we think they're charging him with. Then we're going to go ahead and we're going to see the video of his arrest. So the first one up is the felony, intimidating a participant in a legal process. Which is Kentucky Statute 524.040. And it reads that a person is guilty of intimidating a participant in a legal process when, by use of physical force or a threat directed to a person he believes to be a participant in the legal process, he or she influences or attempts to influence the testimony, vote, decision, or opinion of that person. Now that's the only one that I read that I could see could possibly apply to Chris or his actions. You can go ahead and read through the rest of them here on the screen, or you can look it up on Google. I'll give you the statute again here at the end of this particular statute. But I think that's the only one that particularly applies is 1A. Now we get down here to number 2, and it says, for purposes of this section, an official proceeding need not be pending or about to be instituted at the time of the offense, which is kind of crazy to me, because it seems like they can use this statute at any time and just say, well, there's a court case in the future, maybe. I don't know. It's kind of weird. The testimony, record, document, or other object need not be admissible in evidence or free of a claim of privilege. And again, that wouldn't apply. Intimidating a participant in the legal process is a Class D felony. In order for a person to be convicted of a violation of this section, the act against a participant in the legal process or the immediate family of a participant in the legal process shall be regulated to the performance of a duty or role played by the participant in the legal process, which is a whole bunch of legalese right there. But from what I can see, 1A is probably what he's going to be charged under. Probably literally the only thing he could be charged under. Now, I took a couple of minutes and we went to the Kentucky courts on Google Scholar, and what we find is that in this case is Larry Godby versus Commonwealth of Kentucky. It's 187 SW3D 857. 2005 is the case site. It's from the Court of Appeals of Kentucky. And basically it's saying here, it says, we opine that a threat to injure a person encompasses physical injury only under 524.040. So basically the only way that he could be charged under that statute is if he physically tried to intimidate somebody in person to, change his vote or, his testimony or something of that nature, or if he made a threat of physical force, like, if you don't vote this way, I'm gonna kill you, or if you don't, change your testimony to say this, I'm gonna come over there and mess you up. So it's got to be a threat of physical injury, and it's got to be directed to the person that's involved in the legal proceeding. So I'm not seeing where they're gonna be able to hang this on. So that's the felony charge, which is the first charge. It's the biggest charge. I think that's the most important one to worry about. I don't think, Meade County's got a chance in hell in proving this case there. Again, not legal advice. This is the misdemeanor we think that he's charged under, 525.085. Dissemination of personally identifying information. It says, for the purposes of this section, dissemination means electronically publishing, posting, or otherwise disclosing information to a public internet site or public forum. It then goes through to say who a household member is, immediate family member. And D, personally identifying information means information that identifies or reasonably can be used to identify an individual, including but not limited to Social Security, date of birth, home or physical address, electronic mail or address or telephone number, financial account number, biometric health or medical data, school or employment locations. Alright, those are personally identifying information. Now, I don't know if you need more, one or more in conjecture, right? Because I don't know. Okay, it doesn't say name. So he'd be charged under 2. A person is guilty of disseminating personally identifying information about another person when and with the intent to intimidate, abuse, threaten, harass, or frighten a person who resides in the Commonwealth. He or she intentionally disseminates the personal identifying information of that person or a person's family member or household member, and the dissemination would cause a reasonable person to be in fear of physical injury to himself or herself or to his or her immediate family member or household member. This section shall apply to electronic communications originating within or accessible within the Commonwealth. And then it goes on to say it's a Class A misdemeanor unless it's involved in a serious or death. Nothing in the section imposes a liability on the broadband internet provider that is used in the public forum internet site. This one's going to be hard for them to prove as well, I think. And it's going to be with the intent, right? That's going to be a problem. And this is going to be a problem. So unless there's some kind of threat associated with the personal identifiable information, I don't think that this one's going to fly either. But again, I'm no lawyer. This is no legal advice. As you know, judges and courts and DAs and juries, they, all see things differently. So, that's why it's always a crapshoot when you're, doing this kind of activity. It's always a crapshoot, which I always tell people, do not get arrested if you can help it. Do not get arrested. No matter how well you think you know the law, do not get arrested. Try not to get arrested. Alright? We're going to stop the talking here, guys. We're going to watch the video. It's real short, 2 or 3 minutes on Chris's arrest for this warrant. And we'll keep bringing you guys information as we know more. Alright?
Hey, cop. Both hands. Don't shoot.
What's up, Chris?
What's up, man?
Go ahead and hop out. You got a warrant.
For what?
For what?
I'll tell you when you get out. Go ahead.
No, you can tell us right now.
For what?
It's out of Meade County. Go ahead and hop out.
For what? Don't reach in our car.
How about Chris?
For
Boy.
what?
I'll show you in a second. stay in the car, man.
How about you don't worry about what
Go
I'm
live.
doing?
You can just stay in the car.
I'll stay right here. I have every right to get out of the vehicle. Don't tell me what to do. That's what I highly recommend of you right now.
Big Newton.
Fig Newton?
Super Newton.
Oh, what's your badge number, Newton?
9235.
What do you have to have, like,
You might ought to call our sheriff. I'll be in
You're
Meade.
saying intimidation, Tiffany.
That's bullshit.
It is bullshit.
I'll be in Meade tomorrow. I want a copy of the warrant. I know you.
Attorney can get it.
We don't have an attorney, obviously. You're just now arresting him.
So they're just making shit up to try to get me in trouble. Right?
I'll let you see the warrant.
You know, I need to call Thomas after this too.
I will.
Get your bottom towards the engine. Stay at the car, please.
I'm not in the car. I ain't getting in the car. I ain't staying in the car.
Well, that's because JJ Scarborough keeps trying to poke it.
Good luck, Tiffany.
I got you.